If you found yourself charged with a crime and your claim is self-defense, you must watch this entire video. In this webinar, I'll discuss the law regarding self-defense in Pennsylvania. I'll discuss second and subsequent defenses, such as voluntary manslaughter and involuntary manslaughter. I'll talk to you about trial strategies and appeals and PCRAs where your lawyer was ineffective for failing to ask for a self-defense instruction. Please enjoy. Hi again. My name is Lonnie Fish from the Liberty Law Team. I've been a lawyer now for 18 years, and I practice criminal defense and personal injury. So if you've been injured or arrested, feel free to call us here at the Liberty Law Team. Today, I hope to have a very comprehensive webinar regarding self-defense in Pennsylvania. I hope that you watch this entire video and have some confidence in me that I can help you with you or your loved one's case if you've been charged and feel that self-defense or some other technical affirmative defense could be in play. So first things first, I'd like to discuss the preliminary hearing with regards to self-defense. You cannot argue self-defense at a preliminary hearing. The standard at the preliminary hearing, as you all know if you watch some of my other videos, is that the Commonwealth must prove a prima facie case against you. And the judge at the preliminary hearing cannot question the credibility of the witness, nor can the judge accept any affirmative defenses such as self-defense and insanity. But the preliminary hearing is very important, especially in a self-defense case, that we set it up, and it's very important that your lawyer knows the law. So let's talk a little bit about the law of self-defense and how it applies in Pennsylvania. There's different types of self-defense in Pennsylvania. Chapter 5 of Title 18 of the PA Code in Pennsylvania generally outlines the law of self-defense here in Pennsylvania. There are definitions of the terms of believes, belief, and other really important terms that you need to be aware of in Section 501. But it also outlines the types of self-defense. The types of self-defense, there are 5 sections of use of force that are generally accepted. The first is use of force in self-protection. The second is use of force for the protection of other persons. The third is use of force for the protection of other property. The fourth is use of force in law enforcement. And the fifth is use of force by persons with special responsibility for care, discipline, and the safety of others. In this webinar, we're not going to talk too much about use of force in law enforcement and use of force by persons with special responsibility. But if you have any questions with regards to those, feel free to give us a call. We're mainly going to focus on 90-some% of the self-defense cases, which would be the first 3. First, I'd like to talk about some of the terms that you're going to hear that are very important. Believes or belief is a really important legal term, and it's specifically defined by reasonably believes or reasonable belief. That is, and you'll see later, that if the jury or judge, in the case that it's a judge trial, actually believes that the defendant really did believe what they were doing was necessary or something else, as we'll talk about later, that belief has to be reasonable. So that's a very important thing that you need to understand. It also defines what deadly force is versus non-deadly force. So you'll see there's different standards when it comes to deadly force or non-deadly force. In the instance of deadly force, that's defined as force that is readily capable of causing death or serious bodily injury. So when we talk about readily capable, that's the use of a gun, a knife, a bat, even a vehicle, or something that's for sure going to cause death. The reason that we have that distinction, as you'll see later, is that you can't use deadly force in certain situations. If you use non-deadly force and the person's up dying, you might not be culpable for that crime. The term residence is also defined, which is important in castle doctrine cases. It's defined as a dwelling in which a person resides, either temporary or permanently, or visits as an invited guest. We'll talk about it a little bit later, and it's important in cases that involve common areas, such as an apartment building, or even in places that have curtilage. Unlawful force is used, unlawful force is denied. Unlawful force is defined as force, including confinement, which is employed without the consent of the person against whom it is directed, and the employment of which constitutes an offense or actionable tort, or would constitute such an offense or tort except for a defense. It goes on to elaborate and says, such as the absence of intent, negligence, or mental capacity, duress, youth, or diplomatic status. It's a very complicated definition, so obviously that's why you have a lawyer here in place. Let's talk about justification generally, that if you raise it as a defense and the court accepts it, for example, if it reads the jury instruction or applies this jury instruction, it's the Commonwealth's burden to disprove the justification beyond a reasonable doubt. In other words, in any prosecution based on conduct which is justifiable, justification is an absolute defense to the crime. Justification generally means conduct which the actor believes to be necessary to avoid a harm or evil to himself or to another is justifiable. So there also is some discussion regarding what's called choice of evils. And what you really need to understand simply is that if some actor with their own reckless or negligent conduct, it brings about the situation requiring a choice of harms or evils because of their own conduct, the justification defense is unavailable. So you have to be free from being the aggressor in a situation, in other words, or other situations to be able to claim self-defense. Let's talk about some of the limitations on justifying the necessity for the use of force. The use of force is not justifiable in this section unless the actor believes that such force is necessary to protect himself against death, serious bodily injury, kidnapping, or sexual intercourse compelled by force or threat. Let's talk about that limitation. Is that if somebody comes to me not with a baseball bat, not with a gun or a knife, but with their fists, so long as that person's not Muhammad Ali or Mike Tyson, I can't then shoot them. In addition, there's a few other limitations with regards to the use of force. The use of force cannot be used in a situation where the actor, with the intent of causing death or serious bodily injury, provoked the use of force against himself in the same encounter. In other words, you couldn't have started it. There are many other limitations with regards to the use of force. So I want to talk to you a little bit about something that's considered to be the castle doctrine. So it is presumed that you have a reasonable belief that deadly force is immediately necessary to protect yourself against death, serious bodily injury, kidnapping, or sexual intercourse compelled by force or threat if both of the following conditions are met. That the person against whom the force is being used is in the process of unlawfully or forcibly entering, or has unlawfully or forcibly entered and is within a dwelling, residence, or occupied vehicle, or the person against the force is used is or is attempting to unlawfully force or remove the other against their will from their own dwelling, residence, or occupied vehicle. And secondly, the actor knows or has reason to believe that the unlawful forceful entry or act is occurring or has occurred. That's called the castle doctrine. So let's break it down in layman's terms. That if you're in your home, whether it's rented or owned, or actually if you're in your car and somebody's trying to break in, there's a presumption that your belief is reasonable. It's a rebuttable presumption, but it's very difficult to overcome it. So what does that mean? That if you're in your home and somebody's breaking in and doesn't have license to be there, you can shoot them. That your belief is reasonable. You don't have to wait and see if they have a gun in their pocket or if they're going to. You don't have to wait for them to start harming you. You don't have to wait for them to start using force against you. That you can use lethal force in this situation. It's reasonable. You also don't have the duty to retreat when you're in your own home. I want to talk to you a little bit about stand your ground. That is defined as the following: that an actor who is not engaged in criminal activity, who is not in the illegal possession of a firearm, and who is attacked in any place where the actor would not have a duty to retreat under paragraph 2 the little I, has no duty to retreat and has the right to stand his ground and use force, including deadly force, if the following conditions are met. Number one, the actor has a right to be in the place where they are attacked. Number two, the actor believes that it's immediately necessary to do so to protect himself against death, serious bodily injury, or kidnapping. And three, the person whom the force is used displays or otherwise uses a firearm or replica of a firearm or any other weapon that is readily apparently capable of lethal use. Let's break that down. If you're somewhere where you don't have the duty to retreat, such as your home or possibly your job or in your vehicle, and you're confronted by somebody who, and you're confronted by somebody who's using a gun or replica gun, possibly a knife or something along those lines, you do have a right to stand your ground and do not need to retreat. Let's talk a little bit about the use of force for protection of others. The use of force towards the person of another is justifiable to protect a third person when the actor would be justified under the earlier sections using force in self-protection is using the force to protect himself against injury and he believes to be threatened to the person who he seeks to protect. Two, under the circumstances that the actor believes them to be, that the person who he seeks to protect would be justified in using the protection force themselves, and the actor believes that his intervention is necessary for the protection of such other person. The exception is that the actor is not obliged to retreat to any greater extent than any person he seeks to protect. And let's give you an example of when it would be appropriate to use use of deadly force to protect another person. Let's just say that I'm on the street and carrying a legal firearm, and I see somebody on the ground with another person on top of them about to take out their knife and stab them. I would be justified in using deadly force and protecting that individual, who is or believed to be by the actor in his possession or possession of another person who he seeks protection of. And you also have to believe that the person against the force is using has no claim of right to the possession of property and land. Now, it's important to note that there is no mention of deadly force in here. So I would suggest that you can't use deadly force in the protection of property. Also, you can't attack a random person that's entering a property. You have to have a reasonable belief that that person doesn't have license to be there. So I would suggest that nobody uses this on somebody else's property. That has to be to their own property. There's a limitation that you need to be aware of. The use of force is justifiable under section only if the actor first requests the person against whom such force is used to desist from interference with the property, unless the actor believes the following: that such requests would be useless, that it would be dangerous themselves or another person to make that request, or substantial harm will be done to the physical condition of the property which is sought to be protected before the request can be effectively made. So in other words, you have to say, hey, get out of here. But obviously there's some limitations to that requirement. The use of force in self-defense is amazingly complicated, but the law is generally beautiful. And it's hard for somebody who's on the street to possibly consider all these factors in the heat of passion, of some sort of altercation or some other event. Although this webinar is designed to be informative, the general advice that I'll give anybody is to do what's right, is to simply use your common sense. That if somebody comes to you and threatens force and you can reasonably retreat, you should do it. Makes sense. It's also impossible to contact a lawyer in the middle of an altercation. I wouldn't take any of this advice. And it's important to note that the law is ever changing. So while the purpose of this video isn't to give you legal advice, it's to guide you whether defending you in a situation where you're either charged with a crime or being questioned in a case where you use self-defense. It's important to talk about what to do if you're approached by the police and you believe that you've defended yourself. I would suggest that you consult an attorney like myself to go to talk to detectives and or the district attorney on your behalf, because unfortunately, the police and detectives aren't always necessarily looking for you to have a justification argument. They'll often design their questions to counteract the law that they're already aware of. So don't go talk to the police on your own, even if you're right, even if you're justified. You have a right to an attorney and you should contact them.